Our next speaker is Tim McGrainer. Tim is a partner in the Voorhees Columbus office and a member of the litigation group. Tim's practice focuses primarily on oil and gas litigation and commercial litigation. Tim is a member of the American, Ohio State, and Columbus Bar Associations, as well as the Energy and Mineral Law Foundation. Tim received his JD summa cum laude from the Ohio State University, the Ohio State, even a West Virginia girl gets that. In addition, he served as the associate editor of the Ohio State Law Journal. He received his BA summa cum laude from the Ohio State University, and Tim is a graduate of the Leadership Columbus class of 2014. Welcome, Tim.
Good morning. Happy St. Patrick's Day to all of you. I'm excited to be here today to talk and give to you the legal update. 2015 was an exciting year in terms of the law. We had a large number of cases over the past year. In preparing for today, I did a quick search to see how many cases there were in 2015 and early 2016 that actually discussed oil and gas leasing. I found 84 cases decided in the last year alone that talk about oil and gas leasing issues. So there was a lot. You're going to be happy to hear that I'm not going to talk about each and every one of those 84 cases today. But I'll give you some of the highlights. There were a couple of big Supreme Court cases that we had. I'll talk about those. But I did want to give you a sense of the volume of cases that we've been seeing. The number of cases this year pretty much matched what we saw in 2014 when there was about 88 decisions. 2013, there were 71 decisions. To give you a point of comparison, in 2010, when the Utica Shale play began, there was only 5. There were 5 cases in the entire year that talked about oil and gas leasing. So I think what we've seen in the last 5 years is there's been a huge learning curve for the courts as they come to understand this industry and the law that governs this industry, and they've been looking to other states to reach decisions. And I think we're seeing better decisions today than we saw at the beginning of the shale play, more reasoned decisions, and just a better understanding of how to govern this industry. Here are some of the things we're going to talk about today. We're going to talk about Dormant Mineral Act issues. This is an area where we actually have more questions than answers at this point, but I'll talk about some of the questions that we hope to be answered in the next year or so. We'll talk about cases involving lease validity. Those are challenges to the validity of your oil and gas lease. We're going to talk about local efforts to just flat ban oil and gas development within a city and how those are faring in the courts. We're going to talk about a series of cases involving pooling and production issues, things like whether your lease is producing and paying quantities or not, and whether the lease is properly pooled or not. We will talk about cases where the leases have been assigned, either partially assigned or completely assigned, and whether a landowner can actually block you from assigning those leases. We'll talk about a few other miscellaneous issues. Those are pretty fact-specific. I'll just kind of highlight what's out there. And then I'm also going to give you a preview of some coming attractions of cases that are going to be decided in the future. Okay? So let's talk about the Dormant Mineral Act first. The headline here is the case of Chesapeake Exploration versus Buell. That was decided late last year. The big takeaway in this case, there were 2 questions that were addressed. First was, is an oil and gas lease a title transaction under the Dormant Mineral Act? The second was, is the expiration of that lease a separate title transaction under the Dormant Mineral Act? And just so you know, I'm sure you have this background already, but under the Dormant Mineral Act, there are certain events that can occur during a certain period of time that will save a mineral estate from being revested back with the surface estate. And title transactions involving the oil and gas rights are one of those savings events that will prevent revesting of that mineral interest. The Dormant Mineral Act doesn't actually define whether an oil and gas lease is one of those events that can prevent that revesting. And so the Supreme Court decided late last year whether that oil and gas lease is in fact a title transaction. The answer was yes, it is. So if you have a lease that is recorded within the relevant time frame of the Dormant Mineral Act, that acts as a title transaction that blocks the mineral estate from revesting with the surface estate. In reaching that decision, the court held that there was vast rights given under the oil and gas lease to the lessee. Now, what the court did was stop short of saying exactly what those rights were or what we call those rights. They talked about things, and this is a legal phrase, fee simple determinable, but they didn't want to actually define what the ownership interest created under an oil and gas lease was. For their purposes, it was sufficient to say it means a lot. It does have a tremendous impact on the ownership rights and the ability to develop the mineral estate. We're going to call this a title transaction under the Dormant Mineral Act. In other words, it affects title to those minerals. On the flip side, when that lease expires, say it's a 5-year lease, is the expiration of that 5-year primary term itself a title event that will save the lease from being, will save the minerals from being revested into the surface estate? The answer to that is no. And the reason for that is the unrecorded interest doesn't tell anybody that anything has happened. So if the expiration of the lease has not been recorded, nobody knows whether that lease is still in effect. Nobody knows whether there's a producing well on the property by going to the courthouse to look at the title work. So because there is no notice to third parties, the Supreme Court held that that is not a title transaction for purposes of the Dormant Mineral Act. So that was the decision that was reached during the year, and I'm having trouble here with our clicker. Oh, there we go. That case was recently followed by the case of McLaughlin by the Sixth Circuit. We're having, there we go. So what questions are unanswered? There's a lot of those. One of them is whether the 1989 Dormant Mineral Act was self-executing or not. And that means, did a surface owner have to take some action in order to make their mineral estate revest with the surface estate, or whether that happened automatically as a matter of law. And that question has been argued before the Supreme Court in a couple of cases last year. We expect to see a decision on those sometime probably in this year. Another question is, does the Marketable Title Act have any role to play with respect to Dormant Mineral Act issues? That was also argued in the Walker case last year. Sorry about that. Is the payment of a delay rental a title transaction under the Dormant Mineral Act? That was argued in the case of Corbin versus Chesapeake last year. Is the recording of an out-of-state will a title transaction? One question that was left open in the Buell case is whether the recording of the expiration of an oil and gas lease is a title transaction. That was mentioned in Buell. They made great pains to note that the expiration was not a recorded event in that case. What happens if you do actually go out and record an expiration of your oil and gas lease? Does that become a title event under the DMA? We don't know, and I'm not aware that there is a case that's pressing that issue right now. But the other questions have been argued to the Supreme Court, and we expect to see decisions on those reasonably soon. I would say, not a prediction, but I would say sometime in 2016. Let's talk about some lease validity cases. there was a series of cases that were filed early in the shale play that talked about whether an oil and gas lease that had a primary term in which you could pay delay rentals was actually void as a perpetual lease under Ohio law. Most of us thought that was a pretty silly argument to make, but there was a couple of common pleas courts that said, in fact, well, no, you can't have a delay rental provision that would apply, and because of the way the leases were written, that delay rental would apply in perpetuity. You could just keep paying year after year, and it didn't matter whether it was a 5-year lease or not. Didn't make a lot of sense to a lot of us who actually understand oil and gas law, and as I said early in the play, the courts didn't understand oil and gas law either. So we did see some cases at the trial court level that held that those types of leases, which is a standard oil and gas lease, were actually void as against public policy. Those cases bubbled up to the Supreme Court, and early this year, the court decided the case of Clougus Family Farm versus the 7th District Court of Appeals. And the Supreme Court emphatically said, no, those cases are not void as against public policy. The two arguments that the landowners raised were that the delay rental provision applied in perpetuity and delay rentals could be paid in perpetuity. They also argued that language in the lease, which is pretty standard, that the lessee could determine in its judgment whether the lease was capable of being produced, rendered the lease void because it gave the lessee too much discretion in terms of deciding whether the lease was capable of being produced. The court rejected both of those arguments. It held that the delay rental provision only applies during the primary term, which is what everybody really understood this to mean. And it also held that the phrases capable of being produced and in the judgment of the lessee don't apply to the lease in the abstract or the land in the abstract, which is what the lessors were arguing in that case. Instead, it requires a well to first be drilled from which the lessee can determine whether it's capable of production. Because there was some activity that was required under the lease during the primary term, those leases are not perpetual, they don't last forever, and thus are valid under Ohio law. These cases here were the 7th Appellate District applying a similar analysis and upholding those leases. Another series of cases that we saw at the start of the shale play were whether some defect in the notarization of an oil and gas lease would render that lease void. Those cases, I think, have petered out, and we don't see many of those now. But this case, decided late last year, also clearly held that a notarization defect does not render an oil and gas lease void. So if there's a problem with the notary wasn't actually there, the notary took the notarization by phone, those types of issues aren't going to defect your lease. What it may do, however, is create issues if there comes what's called a bona fide purchaser. So if somebody comes in and buys the property or leases the property directly from the lessor, you may have issues with those folks if you have a defect in your notarization, but that's a separate issue. The lease itself is not void as between those original parties to the lease. So when a landowner is making these types of legal challenges to the validity of the lease, what happens to that primary term? As we know, we only have a limited window in which we can act to develop the oil and gas. What happens if a landowner files a lawsuit in year 3 of your primary term and says this lease is void? Do you have to drill within that 2-year period? What happens? In Ohio, what has been happening is that the courts have applied what's called equitable tolling, which basically puts a stop on the running of the primary term, a pause button, if you will, to prevent that lease from expiring just because the lawsuit was brought. The Supreme Court adopted this view in the Clougus case that was decided earlier this year, and it held that the court did have the jurisdiction to issue that kind of a tolling order. The Baxter case that I just mentioned also said that the primary term was tolled. And a recent case decided last week, the Summit Crest case, the 7th Appellate District also said that tolling was proper in that case. So that's how the courts are preventing a landowner from simply running out the clock on their primary term by filing a lawsuit. Plaintiffs have argued that the failure to pay royalties renders a lease void. The courts have said, no, that's not true. Your remedy if I don't pay you on the oil and gas lease is you sue me for money. You don't get to cancel the lease itself. You just file a lawsuit for money damages equal to the amount of the unpaid royalties. And the recent case of Armstrong versus Chesapeake decided that issue. But there's an exception. If your lease does in fact say that you must pay me or the lease terminates, then you must pay or the lease will terminate. The Sims case, the royalty provision actually defined a $400 minimum royalty as being required under the lease. Lessee did not pay $400. They paid $391.45. The court said that was not good enough. The fact that they were $8 short terminated the lease. So you've got to read your leases to make sure that you're complying with these types of provisions to make sure that you're not giving a landowner an argument to get out of their lease. Shifting gears, there were a series of municipalities that enacted what are called charter amendments. These charter amendments were designed to block oil and gas development within those city limits. Recently, the 8th Appellate District, earlier this year, held that those types of charter amendment bans are invalid under Ohio law. A city does not have the ability to trump Revised Code 1509, which gives the Department of Natural Resources the sole and exclusive authority to regulate oil and gas. A city can't go out and enact its own ban. Here, the city of Broadview Heights had enacted an ordinance that made it unlawful for any person or corporation to engage in the extraction of gas or oil within the city. It also made it unlawful to transport any wastewater through the city limits. The court said that no, city, you cannot do this. Now, the plaintiffs in that case were making a unique argument. They were claiming that they weren't acting as a city, so they weren't subject to the Home Rule Amendment, which was the subject of the Supreme Court's case in Morrison. We were really acting as the people as direct sovereigns, not the city. And in their arguments, they cited things like the Articles of Confederation, the Declaration of Independence. These types of things gave them the right to act as a separate sovereign, separate and apart from the state or the city. The court, in a pretty short opinion, said, no, that is not the case. You are subject to Ohio law. These bans are no good. Now, the one question that's left open, I think, between the Morrison case and the recent case out of the 8th Appellate District is what about traditional zoning type issues? Those were not addressed in the Morrison case, and the concurring opinion, 2 justices joined that, along with the 3 dissenting justices, could find that local zoning, traditional zoning type issues might have a role to play with oil and gas development. We have not seen those cases yet. I suspect that we will see those cases in the future. So just be aware that those battles are not yet over. It remains to be seen exactly the interplay between local zoning and oil and gas development. What is clear is that the city can't specifically target oil and gas development. It might be able to apply generally applicable zoning rules, but it's not going to be able to attack the industry through zoning regulations. Let's talk about a series of cases involving production and pooling issues. There are a series of cases that talk about issues of production and paying quantities, which is the general standard for whether your lease is going to remain in effect. Are you producing enough in revenue in order to overcome operating expenses? And there were a series of those cases issued in the last year. Each of these kind of rests on its own facts and is unique to the circumstances there. But there are a couple of points I want to make. The Dennison case was interesting. There was a temporary cessation in that case because there was a mechanical problem with the well. And the well at issue was out of production for about 18 months. The lessor, the landowner, argued that that 18-month period of no production may cause the lease to terminate for lack of production. The operator argued, well, no, we were trying to fix this problem during this 18-month period. The lease hasn't terminated. The court agreed that a temporary cessation doesn't terminate a lease. And that was the big picture there. But the caveat is the lessee has to be engaged in reasonable diligence in order to get that well operating again, in order for that doctrine to apply. There was a 12-month delay in that particular case as a result of trying to schedule a service rig to come out. And it was unclear exactly the efforts that were made to get the service rig to come out, whether the delays were as a result of scheduling or just not calling. The court held that that's all a fact question. That's an issue that the jury is going to have to look at and weigh all of the evidence between the parties and decide whether is that good enough to keep the lease in effect or has the lease terminated. Kind of scary when you're leaving that in the hands of the jury to decide whether your lease is good or not based on those efforts. So the takeaway is you ought to be careful and document all the efforts that you are making when you are talking about putting a well back in production that has mechanical problems. Just make sure that you're documenting the steps that you're taking to get that well producing again. The Holland case was interesting. The trial court there had terminated a lease for lack of production. The Court of Appeals reversed only because an overriding royalty owner was not joined as a party. The court held that that was a necessary party to the action and reversed the judgment and told the trial court, you've got to make them a party. They've got to be brought in. So I think what you're going to see as a result of that is if you own overrides in wells, you're going to see more lawsuits because plaintiffs are going to be afraid that if they don't join you, they are not going to be able to prevail. Moberly talked about the types of production records that are filed with ODNR and whether those are important for evidentiary purposes in determining whether a lease is producing and paying quantities or not. The court said no, whether you filed a report with the state doesn't really matter. What matters is whether you have production records in your records that you can show that you were producing. Casto, there was a 7-year gap of no production. The court unsurprisingly held that that was not a valid lease any longer. And then the Schultheis case was, I think, another important one that I want to make you aware of. In that case, there was a 4-year gap in production. There was 4 years in which the lease was not producing at all. That 4-year period was 1977 to 1981. So 22 years before the lawsuit was filed. The court said, doesn't matter. Even if it was that long ago, it was proper for the plaintiffs to bring that lawsuit, and the lease was terminated on that basis. So what's troubling there is there a limit on when plaintiffs can bring these lawsuits? If 22 years is not long enough, 30, 50, I don't know the answer, and those issues are going to continue to play out. But it's a little scary to think that a plaintiff landowner can go back in time for some undetermined period of time to look and see if they can find a gap. There were another series of cases that talked about development issues, and those involve whether you had to drill multiple wells on your property in order to maintain the lease. Those can happen either as an applied obligation under the lease, or they can apply with an express provision under the lease. The Core versus Samurai case from late last year appeared to suggest that you look at that question just on a pure acreage basis. In that particular case, the Core case, there was 110 acres that were developed under the lease. There was 400 acres that were undeveloped. The court looked at those two numbers and said, well, gosh, you have not done enough to develop this lease. You have breached your implied duty to develop, just on those two facts. But the court went on to say, but the normal remedy for that kind of a breach is not to release the acreage or terminate the lease. The normal remedy for that kind of violation is money. What the plaintiff was really entitled to was the royalties that they would have gotten from those additional wells that you should have drilled. So that's their remedy. You need to go back and calculate how many wells would have been drilled, what the royalties from those wells would have been in order to determine the remedy. And it's up to the plaintiff to show either that that's not good enough or that they can't do it. That burden is not on the lessee. So it's bad in terms of them looking at simply the acreage. It was good in terms of the remedy that the court was looking at. The Cox case involved multiple wells and a Pew clause. The court applied the lease as written. But again, the court held that the statute of limitations did not apply in that particular case. And then the recent case of Summit Crest, there was a continuous development clause in the lease that required a well to be drilled, I think it was every year after the primary term ended. The lessor was trying to argue that that clause applied during the initial primary term, and the court said no. That type of obligation in that lease only applied after the primary term expired. I want to talk about a couple of pooling cases. Again, these types of cases really depend on your specific facts. They depend on the specific leases that are at issue and the provisions in those leases. There was a case decided just 10 days ago, the Eclipse case. I put this one here just because there's more color for you to look at. In this case, you're going to see a red and white lateral. Those were off the unit that was in question. The plaintiff landowner had signed a subsurface easement in order to allow the operator to drill off the development unit back into the development unit from the well pad. The lessor argued, here, I'll leave that up for a second. So the black area is the unit in question. The red and white laterals there were off the unit. The red laterals were on the unit. There was an adjoining unit that was contemplated to be developed as well, and they were going to use that same green well pad to develop that unit. The lessor was arguing, well, you needed to get a subsurface easement to go off my unit and back on. That means you need a subsurface easement to come from the well pad to develop those units in the blue. The court said, no, that is not true. You had the right under the lease to drill under the property to develop adjoining properties. The fact that they went out and got a subsurface easement for a different reason doesn't change your lease. Another pooling case, K&D Farms versus Enervest Operating. There were 2 Rose Run wells that were drilled. For some reason, they were not included in the consolidation that had been previously recorded. The plaintiff landowner said, aha, you didn't include those in your filing with the state. That must mean I am not part of the consolidation, and you only pay me. You don't pay the other landowners who were part of the original consolidation. The court again said no. An OD&R filing is not going to change the substantive terms of your lease. The lease itself applied to the entire consolidation. The consolidation applied to all depths. The fact that you were drilling Rose Run wells when the original consolidated unit involved Clinton wells doesn't matter. The consolidation applies, and you're going to have to pay all of the consolidated landowners proportionately. In this case, again, late last year, there was a declaration of pooled unit that was filed. It applied to what they called the Smith well in that case. The Smith well was never actually drilled or completed, so there were never any operations or production from the Smith well. They then permitted another well, but they didn't file a separate declaration of pooled unit relating to that well. They permitted that well just 10 days before the expiration of the primary term. The landowner said, well, you haven't drilled it. The lease is expired because you didn't do anything to develop my property during the primary term. The court agreed. The lessee had argued that the earlier consolidation ought to apply to the new well. The court said no. There was no new recording of a consolidated unit to talk about the new well. There was different acreage involved and consolidated. There were different parcels. We're not going to allow you to use a second well to hold this lease. And the court held that the lease was no good. There are a couple of assignment cases I want to bring to your attention. Can the lessor who has a consent to assign provision actually block you from assigning your lease to somebody else? In some cases, yeah, probably. There are two lines of thoughts. There's two lines of thought in Ohio on these types of provisions. One line of cases says if the lessee is doing it just for money, they just are trying to extort more money, you can't do that. There has to be a commercially reasonable or commercially viable reason that they want to block you from assigning to somebody else. Maybe the new operator isn't a viable entity, some reason like that. But there's another line of cases in Ohio that says, well, yeah, they can do it for any or no reason whatsoever. And if the reason is they want to get money, that's okay. The second line of cases is an older line of cases. And what the Love case here said was because the lease was signed when that older line of cases, the for any or no reason line of cases, was really the predominant view, we're going to apply that law to the lease and say that this landowner can go ahead and block the assignment just because they want to get more money. But again, the normal remedy for these types of cases, you don't void the lease. All you do is you unwind that assignment, and so the lease goes back to the original lessee. The lease itself doesn't go away. The Marshall case talked about horizontal severances, so I assign the deep rights to another operator. I keep my shallow wells and continue to operate them. Does the deep operator have a duty now to separately develop those rights by drilling a Utica well on that property? The answer is generally no. Courts do not find that there are separate zones that are created. What happens is the shallow rights will continue to hold the entirety of the lease. There are a few other cases that have been decided. These are pretty fact-specific, so I'm not going to talk about these in any real depth. I just want to make you aware that these cases are out there as well. Talking about extensions of leases and when you have the option to extend a lease, what you have to do, whether the lessee has a right to get third-party offers during the primary term of the lease and what effect that has, cases involving free gas issues, which, as we know, was a reason that a lot of landowners actually signed their leases in the first place because they wanted that free gas. And then rights under purchase and sale contracts. And all of those really depend on your particular case. Another case that is bubbling up, but it hasn't hit Ohio yet, is the recent bankruptcy decision of the Southern District of New York and the Sabine bankruptcy. In that case, the court held that the debtor was allowed to reject their gas gathering contracts. And what that means in the bankruptcy context is that becomes a breach of those agreements, but then those agreements are just a pre-petition claim like any other. And so the debtor is then free to go out and get different gathering contracts. They're allowed out of those contracts. The gathering companies were arguing that these are really real estate interests, and so they don't have the right to reject those, but the court held to the contrary. Those are probably that case is going to get a lot of play throughout the country in oil and gas, E&P bankruptcies, and so this is a pretty new decision, so we'll see how that plays out. And then a few cases that are coming up. There is a case before the Supreme Court right now that was argued earlier this year, the Lutz versus Chesapeake Appalachia case. It talks about how royalty and post-production costs are treated. We shall see what the court does with that. There's a chance that the court could simply kick the case back to the district court, not answer the question, or the court could decide to adopt a particular view of this issue in Ohio that has not been adopted. Ohio law is just silent on whether we follow the marketable product rule, which does not allow for post-production costs to be developed, or whether we follow the at-the-well rule, which does allow those costs to be taken into account when calculating your royalty. We just don't know the answer to that. This case would present the court with the opportunity to decide that issue, but we'll see if they actually take that opportunity. There's a case pending in the 7th Appellate District right now that talks about whether a landman, an independent landman, must be registered as a real estate agent in order to be able to collect a fee for their work as a landman. That case is on appeal right now, and the briefing is ongoing, so we'll see if and when that decision comes out, how that comes into play. And that is it. I think we have a little bit of time for some questions.
We have time for 1 or 2 questions.
And if anybody wants a copy of this for whatever reason, perhaps late night reading, my email's here. Just email me, and I'd be happy to send you a copy. Okay? Thank you.